the plaintiff calls Dr. Campbell Solo to the stand. Chris Sample for the plaintiff. May I proceed?
You may.
Good morning. Please introduce yourself to the members of the jury, spelling your last name for the record.
My name is Dr. Campbell Solo, S-O-L-O.
Dr. Solo, what do you do for a living?
Well, I began my career as a staff psychologist at Breckenridge County. From there, I became an adjunct professor of psychology at Midland State University, and currently I run my own practice, Solo and Associates.
What education do you have?
Well, I began my academic career at the University of Oregon, where I obtained my Bachelor of Arts in Psychology. Went on and got my medical degree from the University of Michigan, where they called me campus soup. From there, I did my general psychiatry residency at St. Madison's Hospital. Then I did my child and adolescent psychiatry residency.
What is your role in today's case?
Well, I was hired to examine two questions, whether Jesse Duran posed a special danger, and if this danger manifested before August 18, 2010.
For your work in today's case, did you have sufficient facts and data?
Yes, I did. I had access to a number of affidavits, including Hanny Duran, Danny Brooks, Andy Park. I had exhibits and other evidence.
Did you use reliable principles and methods?
I know of no other way to do my job.
And did you rely on those principles and methods reliably to the facts and data that you received in today's case?
Yes.
What was your conclusion?
Well, first off, to answer those two questions, yes, Jesse Duran posed a special danger with regard to firearm, and yes, it manifested before August 18, 2010. Also, when formatting my conclusion, I've come across 3 risk factors I found in Jesse, which are based off a number of peer-reviewed studies that these risk factors increase violence and behavior in children.
I want to break this apart for the members of the jury. What's the first risk factor?
Well, the first risk factor I found in Jesse was exposure to violence in media. Now, Jesse was extensively exposed to violence in media, specifically violent video games, in which Jesse's father, Hayden Duran, played these video games with him and bought these first-person shooter games with him, for him. First-person shooter games are the player or their controllers in the eyes.
Objection, Your Honor. Here is the court answer. We're way beyond the scope of the question at this point.
Do you happen to recall what the original question was?
The question was, how are you aware of Jesse's regard to exposure to violent media? He's merely going on and on rambling about how he was exposed to violent media.
No need. I'm going to overrule. I mean, he's an expert and he has a lot to say, and as long as he's talking about Jesse and violent media, he gets a little more leeway.
Yes, Your Honor.
Dr. Sully, you were talking to the members of the jury about Jesse's exposure to violent media. Can you continue, please?
Well, yes. Like I said, Hayden Duran bought Jesse first-person shooter games, and these games are the player or the controllers in the eyes of the shooter himself. Studies have shown that children who play violent video games or view these types of programming are more susceptible to imitating what they see versus children who don't view or play these types of programming.
I want to turn your attention now to your second risk factor. What is that?
The second risk factor I found in Jesse was previous aggressive behavior.
Can you explain that in a little bit more detail for the members of the jury?
Well, when going through this risk factor, I found a number of evidence regarding this claim. The first piece of evidence is the discipline notice sent from Jesse's school to Hayden Duran. This probably is the most heavier piece of evidence I examined and with regard to this claim. It was a referral sent from the school, basically stating that Jesse Duran is being suspended from elementary school for the 3rd time, from striking another student, biting, kicking, punching, etc. dated August 6, 2010.
Now that suspension notice, would you recognize it in court today if I showed you?
Yes, I would.
Your Honor, I'm approaching opposing counsel with plaintiffs 4.
You have the same document, counsel.
I'm approaching the witness with the same.
Thank you.
Dr. Solo, what have I just handed you?
The notification of student discipline, System Justice School.
Does it appear to be a fair and accurate copy?
Yes.
How do you know that this was the disciplinary notice that was sent to Jesse?
Well, it was sent to Hayden Duran and it has the signature at the bottom.
At this time, Your Honor, plaintiff moves into evidence exhibit 4.
I object to hearsay, Your Honor, as to the statements made within said document.
Okay, just the statements contained within it?
Yes.
Response?
Your Honor, pursuant to Rule 801D2B, mentioned by party opponent specifically, because Hayden Duran has signed this document, he acknowledges these facts to be made and adopts it to be true based on his signature, and because of this, it falls under that exception.
You're saying the signature effectively ratifies this as a party opponent statement?
Yes, Your Honor, pursuant to Rule 801D2B.
Does it matter that, who signed this? Hayden?
Hayden Duran, the defendant in today's case.
Response?
Your Honor, I would argue that 802DB does not make the statement made by Hayden. This is still a statement made by the school that is being used for the truth of the matter asserted. It is hearsay and it's inadmissible.
Why do you think that signing the document asserts that all of it's true?
Your Honor, if I may proffer outside the members of the jury, this document says that I have read the notification above and agreed to implement discipline at home so that my child does not repeat this behavior at school. Signing this shows that he manifests this to be true. And furthermore, Your Honor, pursuant to Rule 703, additionally, otherwise inadmissible evidence can be omitted so long as it relates to the expertise of the witness.
Yeah, I think that's probably the better angle here. What's your response to using this as a hearsay document relied upon by an expert to form an opinion that bears directly on this case?
Just because the document was used to form its conclusion does not make an otherwise inadmissible document admissible. This document is still hearsay from the school and is thus inadmissible under Rule 703, which states any document used in forming a conclusion is not necessarily made admissible by the fact that it is used to make that opinion. The underlying facts and data is not admissible just because it's used to form this conclusion.
I'm going to overrule your objection and accept it with a limiting instruction that it only be used to show the basis of his opinion and not to be taken as true. So on those grounds, it's admitted.
Yes, Your Honor. May I publish this to the jury this time? Now, from this disciplinary notice, what can you tell the members of the jury?
Well, they were playing a dodgeball game, and Jesse had loss of temper with another student. He didn't comprehend with Jesse's rules.
Objection, key motive. This document has already been entered into evidence. The jury can read this for themselves.
Is he reading the document?
He is merely restating facts found in said document, Your Honor.
And then I asked the witness to read this document. I asked him, what did you learn from it? That relates to the expertise.
Yeah, I'm going to overrule for now. I understand what you're saying. So, I mean, please don't make it cumulative. Like, if he starts reading, please renew your objection. I mean, he can talk about what the document means in the greater scope, but yeah, there's no need to double over it. So, overruled for now, but...
Yes, Your Honor. As an expert, Dr. Solo, what did you take from this document?
Well, like I said, it goes to the claim of previous violence. Jesse made a statement after playing dodgeball, and when another kid didn't agree or comprehend with his rules, he yelled, "I hit you, you're dead,
Objection,
you need to
cumulative.
fall down and die."
He's explicitly reading off the document, Your Honor.
I mean, if the document's on the record anyways, and like, if you highlight one sentence, I mean, that's not the end of the world. So, I mean, I'm gonna overrule, but with the instruction to move on.
Yes, Your Honor.
So, continue.
I'm retrieving plaintiff's 4. Was this the only piece of evidence that led you to talk about the second factor of bad behavior on behalf of Jesse?
No, actually, I reviewed an email sent from Hayden Durant to a coworker or friend that also highlights this claim.
Your Honor, I'm approaching opposing counsel with Plaintiff's 5. Approaching lips with the same. Dr. Solo, what have I just handed you?
The email sent from Hayden Durant.
How do you know this was an email sent from Hayden Durant?
It has his email address in the front box.
Does this email appear to be a fair and accurate copy?
Yes.
Your Honor, at this time, plaintiff moves into evidence, Exhibit 5.
And I did lack of foundation. They have not properly authenticated this document as being written by Hayden Durant at this point in time.
Response to that?
Your Honor, the expert earlier in his testimony explained that he reviewed a number of affidavits, one of them being Hayden Durant. This witness, using that data, those facts, he has stated that this was written by Hayden Durant, and this was the fact of the email. Because he relied upon the affidavit of Hayden Durant, he can authenticate it for himself.
Now, if I may respond on those grounds. The only testimony we've heard authenticating this document is that he saw the send box say Hayden Durant's email. That in no way, shape, or form authenticates the sender of said email as Hayden Durant himself.
Counsel, just because the expert relied upon it, I mean, how do we know that he relied upon an actual email from Hayden Durant?
Your Honor, I can lay that additional foundation.
Yeah, I understand that the expert reviewed all of this, but yeah, we need to connect some dots here. So I'm gonna
Yes, sir.
sustain for now and allow for more foundation.
Yes, Your Honor.
How do you know that Hayden Durant wrote this email?
Well, like I said, I have access to these exhibits 8, 9, 10, 13, in which this exhibit was found from Hayden Durant. Also, in a couple of affidavits, the police had found this email sent from Hayden Durant's computer inside his home.
At this time, plaintiff moves into evidence, Exhibit 5.
No objection, Judge.
Amen.
Now, what did you take from this email, Dr. Solo?
Well, the first thing I looked at struck me is after reading this, it was dated July 1st, 2010, approximately 3 months after receiving the discipline notice from the school in which Hayden Durant still failed to take any efforts in talking to his son about his behavior. This email basically expresses his deep concern about Jesse only wanting to play violent video games. It also recounts an incident in which Jesse Durant and Sydney Park were playing a violent video game, and Jesse Durant subverted the rules and to no longer shooting the bad guys, they were shooting each other. This goes to my claim as previous violence behavior.
Your Honor, approaching the witness and retrieving evidence. Dr. Solo, what was the third risk factor that you found?
The third risk factor was presence of firearms.
Can you go a little bit more into detail about that?
Well, although Hayden Durant did not own a gun himself or kept one in his home, Hayden Durant had knowledge that the Parks owned a gun. More importantly, Hayden Durant had knowledge. Prior to August 18, 2010, I believe the day before, Jesse Durant expressed his interest in playing with the Parks gun. Even still, Hayden Durant sent Jesse over there the next day. He talked to his son, Jesse Durant, a little bit about their gun, not to play with it. But again, his efforts were plainly insufficient.
From all these three risk factors that Jesse exhibited, did you come to any conclusion in today's case?
Yes, overall I concluded that
Objection has to be answered. He's already stated his conclusions earlier in today's testimony.
I mean, I think this is distinct enough. I mean, he offered 2 conclusions. He's allowed to have a big overarching one if he wants to. So overall.
Yes, Your Honor.
What was your conclusion based on all three of these risk factors?
overall I concluded that there were a number of risk factors, warning signs that Hayden Durant known or should have known with regarding Jesse Durant's behavior. he failed to impose any limits. He failed to talk to his peers, babysitters, anyone basically expressing, hey, I don't want my kids playing with these violent video games or anything of that nature. He failed to have his son evaluated, which is the most important thing to me, being a child psychologist. I have never seen him in my firm, nor his son. Child evaluations is a big, big thing. You can't just brush off someone's behavior.
Thank you for your time, Dr. Couples. At this time, no further questions.
Thank you. Cross-examination?
Yes, Your Honor. Michael Glennon for the defense. Hello, Dr. Solo. I'd like to ask you a few questions today. It's true that you were asked to come to two conclusions regarding today's trial, correct?
Correct.
The first conclusion was whether or not Jesse posed a special danger with regards to firearms, correct?
Yes.
And the second conclusion was whether or not that danger was made prevalent before the events that occurred on August 18th.
Yes.
Now, I'd like to talk about how that danger manifested itself to the Park family specifically. It's true that you reviewed the affidavits of Andy Park and Danny Brooks in coming to your conclusion, correct?
Yes.
And in this affidavit, you found it clear that Danny Brooks had expressed concerns about Jesse's behavior to Andy Park, didn't you?
As well as Hayden Durant.
However, you never found any instance in the reports that you reviewed that Andy Park voiced Brooks' concerns to Hayden, did you?
Could you repeat the question?
You never found any evidence in your reports that Andy Park voiced Brooks' concerns to Hayden.
No, but I did find Brooks, the babysitter himself, to approach Hayden Durant about Jesse Durant's behavior.
Redirecting you to my question, you never saw any effort on the Parks to let Hayden know about what she had been told by Danny Brooks, did you?
No.
I'd also like to talk about the way the gun was stored. It's true that you are aware that Andy Park knew the two children understood where the gun was kept, correct?
According to the evidence, it was never 100% established. It was only indicated.
But Andy Park was under the impression the two kids knew where the gun was kept, yes.
Objection, Your Honor. Relevance. This witness is a child psychologist, and this line of questioning has nothing to do with his expertise.
And you're asking whether or not the children were aware of where the
I'm
gun
asking whether
was?
or not Andy Park was aware of Jesse's danger with respect to firearms and whether or not it was prevalent before August 18th.
This is close enough to his line of work, and if he doesn't know the answer, he can say no.
Yes, Your
So
Honor.
I'm gonna overrule, continue.
Yes, Your Honor. Do you need me to repeat the question?
Yes.
You are aware that Andy Park was under the impression that the kids knew where the gun was kept, correct?
No, I just simply examined that it was indicated Sydney Park knew.
So, yes, it was indicated that Sidney Park knew where the gun was kept.
Yes.
So you never found any evidence that Andy Park made any attempts to move the safe, did you?
No.
You never found any evidence that Andy Park changed the combination of the safe, did you?
No.
You never found any evidence that Andy Park made any attempt to keep the gun safe from Sidney or Jesse, did you?
Yes. It was kept inside of a Galucci safe. The combination was stored away from the gun, so.
But redirecting back to my question, Andy Park took no further action after realizing that Sidney had an idea where the gun was kept, correct?
No. It was never a clear yes or no, so I have no clue.
I'd like to talk about one of the risk factors you talked about during the direct examination, namely presence of violent media. You're under the impression that a parent should inform their child when violence is real or when violence is not real, correct?
Yes.
And they should make specific effort to let their children know that the same violence that they see in media can cause genuine harm to others when practiced in real life, correct?
Yes, they should also impose limits and talk to their friends, their peers, whoever, their babysitters, whoever watching their kids, and tell them, hey, I don't want my kids viewing or playing these types of programming.
In fact, when you reviewed all the evidence before you, you saw that Hayden Durant on 3 separate occasions made an effort to tell Jesse that real-life violence can cause genuine harm to others, didn't you?
I found that Hayden Durant did make some efforts, but again, they were plainly insufficient.
Redirecting back to my question, he made 3 separate attempts to make sure Jesse understood the nature of real violence, correct?
Yes, but according to my professional opinion, they were plainly insufficient.
He even went so far as to make sure that Jesse never had any access to gun-like controllers when he played the video games that he was playing, correct?
This is true, and I do commend him on that.
Now, I'd like to talk to you more about about keeping a gun in the home. You're under the impression that if a parent is to keep a gun in the home, that gun should be secured as safely as possible, correct?
Yes,
That gun, and the parent should make a reasonable attempt to tell their children about the dangers of guns, correct?
yes,
And you believe that the gun should be kept so secure, not only for their child's safety, but for the safety of any of their playmates that come over in the house that has a gun inside of it, correct?
correct.
Now, as we talked about, you found 3 separate instances where Hayden talked about gun safety, didn't you?
I found a couple. He really just told Jesse Durant, "Hey, I don't play with video games." He didn't really go into detail about the dangers of firearms.
Are you saying that Hayden Durant did not go into the dangers of firearms with his son?
According to my standards, no, not they were plainly insufficient.
You're testifying that Hayden never once mentioned the dangers of firearms to his son. Is that your testimony here today?
No, I did not say that. He talked to his son, but they were plainly insufficient according to my standards and going into detail about the dangers of firearms.
So the answer is yes, Hayden did make efforts to talk to his son about the dangers of firearms.
Yes, I said that.
And Hayden Durant did not keep a gun in his home, did he?
No, he did not.
But the Parks did.
Yes, the Parks did, and like I stated before, when my claim of presence in firearms, Hayden Durant had knowledge that the Parks owned a gun, and Jesse Durant expressed his interest in playing with the Parks gun to Hayden Durant the day before August 18, 2010.
Objection to strike the latter half of that statement is not responsive to my question as to the Parks had a gun in their home.
I mean, you asked the question, you live with it, so stay on the record, continue.
Redirecting you back to my question, the Parks did in fact have a gun in their home, correct?
Yes, they did.
Thank you, no further questions.
Any redirect?
Your Honor, there will be no redirect. I ask that Dr. Solo be allowed to step in the stand.
Yep, you may step down.
Your Honor, at this time, the plaintiff calls Officer Dale Williams to the stand.